Thank you for joining us today for the second in this new series of employment law update webinars. So straight in, what are we covering today? Well, I'm joined by my colleague Ellen Parker, a solicitor in our employment and business immigration team, who's going to be running you through the recent changes to the immigration rules. Near the end of the session, I'll jump back in and provide an update on what is happening in the wonderful world of the Employment Rights Bill. This wasn't intended to be a long section, but we've had some updates just this week that have been added in at the final hour, which might take us over our scheduled time. If you need to leave, please do feel free. We're recording the session, so we can send the full recording over to all attendees once it's ready, so you can catch up if you do need to drop off. So no further ado, I will hand over to Ellen.
Thanks all for joining this session today, which has turned out to be a very well-timed webinar as last week the Home Office announced a raft of changes to the immigration rules, which will be implementing the first measures trailed in May's immigration white paper. So during this session, we will be discussing the key changes that have been announced and are soon coming into force, as well as some other potential updates mentioned in the white paper, which might still be in the pipeline. We don't have long together today, so this is going to be a whistle-stop tour of the key changes as there is a lot to cover. But first of all, let's have a look at where are we now. On the 12th of May, an immigration white paper was published, which announced a number of proposed changes to the UK's immigration system. And the clear message of the white paper was that these changes were designed to cut levels of immigration into the UK. The measures announced in the white paper were proposals and not yet law, so were subject to further consultation and discussion. But the white paper did give us an indication of the direction that the government wanted the UK's immigration system to move in. And now we've seen the reality behind these proposals, with the first changes announced in the Statement of Changes to the Immigration Rules, which was published last week on the 1st of July. And this has introduced a whole raft of changes that are being implemented on the 22nd of July, which is really very soon. So looking at these changes in some more detail, there are quite a few changes to the skilled worker route. And as many of you will know, the skilled worker route is the main work visa route available in the UK, which enables employers to sponsor workers in specific roles. And there are a number of criteria for this route, including the role falling within an eligible occupation code from a list of jobs provided by the Home Office, as well as the role meeting a required skill level and a minimum salary requirement. A number of changes to this route are being implemented, and perhaps the most significant one is the skill level for the route being increased from RQF level 3 or A-level equivalent to RQF level 6 or degree level equivalent. And this is effectively reverting back to the situation prior to the 2020 immigration reforms, when the skill level was lowered to address skills shortages in a variety of lower skilled positions in the UK. So this change, this increase in the skill level, means that around 180 roles that have previously been eligible for the skilled worker route will no longer be eligible from the 22nd of July, other than for transitional provisions, which I'll come on to shortly. So this means that roles no longer eligible for sponsorship include a number of managerial roles, for example, so things like retail managers, restaurant managers, a lot of construction roles like stonemasons, bricklayers, roofers, and office-based roles, for example, finance officers. These roles will no longer be eligible for the skilled worker route. And this announcement has understandably created significant concern among employers who currently sponsor workers within these codes. It is important to note that existing sponsored workers and anyone sponsored before the 22nd of July can continue to be sponsored in these codes. So if their visa is coming up to expiry, they can be issued a new certificate of sponsorship or COS in that code after the 22nd of July, and they can apply to extend their visa. And if they switch employers, but their new role stays within that same occupation code, again, they can be issued a new COS and make a change of employment application. And these are known as the transitional arrangements for people who are already sponsored in these job codes. And these transitional provisions are welcome, but they do create some confusion. And anyone who's read through the statement of changes will see that there are now a number of different tables setting out various salary requirements and options for different codes in different circumstances, which is not going to be straightforward for sponsors to navigate. The Home Office have also said that these transitional measures they'll be in place only for a certain period of time. They won't be indefinitely. So unfortunately, there's no long-term certainty for individuals who are sponsored in these roles. On the topic of salaries, another key change which will be felt by all employers sponsoring workers is the increase to minimum salary requirements for a role to be eligible for sponsorship. And the Home Office has expressed that these changes are to ensure that salary requirements continue to reflect the latest pay situation for UK workers. And the key headline is that the general skilled worker minimum salary requirement is increasing from £38,700 to £41,700 per year. In all cases, the salary for a role will still need to equal or exceed the going rate for that role, which, depending on the role being sponsored, could be much higher than the minimum salary requirement itself, that general threshold. And the going rates have also increased, and the updated rates are set out in the Statement of Changes. There are also salary increases in other sponsorship routes, such as the senior or specialist workers route, the UK expansion worker route, and scale-up workers. Transitional provisions won't apply for the minimum salary requirements, so these will be applicable from the date that an application is made. And this means that even if someone's currently already sponsored in the skilled worker route in line with the existing minimum salary requirements, if they make an extension application or a change of employment application to move to another employer, the new salary requirements will apply and will need to be reflected in the COS. The Statement of Changes table set out the updated minimum salary requirements and the updated going rates, but we expect to see the gov.uk web pages updated in line with the new requirements coming into force on the 22nd of July. And now looking at the temporary shortage list, we now have not one but two shortage occupation lists, for now at least. And these lists set out roles where it's recognised that there are skills shortages in the UK. So the roles on these lists benefit from some concessions that would not normally apply when sponsoring someone as a skilled worker. And the Home Office has established a new temporary shortage list, which provides restricted and time-limited eligibility for certain occupations below RQF level 6, that new skills threshold, where there's considered to be a shortage of workers in those roles in the UK. And the temporary shortage list includes roles like lab, electrical and engineering technicians, product and packaging designers, and certain construction roles. The temporary shortage list is currently sitting alongside the immigration salary list, which lists occupations that have been identified as having labour shortages and are therefore eligible for skilled worker visas with a discounted salary. But long term, the Home Office's intention is to phase out that immigration salary list and replace it with the temporary shortage list. At the moment, both lists will expire on 31st of December 2026, but the Home Office have indicated that this date could be moved forward. We also need to cover changes in relation to adult social care, because for anyone working in the care sector, a major change from the Statement of Changes is the closure of entry clearance applications for roles in occupations codes 6135 and 6136, or care workers and senior care workers. And these changes mean that overseas recruitment into these roles under the skilled worker route will cease. And from 22nd of July, these roles are no longer generally eligible for the skilled worker route, as the Home Office has determined that they don't meet the RQF level 6 threshold. And this means that moving forwards, for individuals to be eligible to make an application under these codes, one of the following criteria must be met. So the first is that the applicant must have been legally working for the sponsor in one of these codes for at least the 3 months ending on the date the certificate of sponsorship was issued by the sponsor to the applicant, and the date of the application must be before the 22nd of July 2028. And this reflects a transitional period of 3 years for switching from other routes, so until 2028. Although, again, the Home Office has indicated that these transitional provisions will be kept under review. The other option is that the applicant must have permission as a skilled worker sponsored in either of those occupation codes already, so for example with another employer. Other than in one or other of those circumstances, an individual will not be eligible to make an application to enter the skilled worker visa route in one of these two care worker codes. And given these changes, the current care worker recruitment requirements, which were only introduced in April and required care sector employers to first try to recruit from a pool of displaced workers or existing skilled workers seeking new sponsorship, are being removed. It's also worth noting that the Home Office are trying to get ahead of any employers that might think of using the still eligible occupation code 6131, nursing auxiliaries and assistants, as an alternative to the care worker codes to try and circumvent the care worker codes no longer being available. The Home Office has clarified that this code 6131 will now only apply to roles in environments where registered nurse roles also exist. There are other changes set out in the statement of changes, so that's not a comprehensive list, but those are likely to be the changes that will make the biggest impact on businesses sponsoring workers in the UK. And now looking forward to what other changes we might see that were indicated in the white paper, but which haven't yet been formally announced. There could be some changes to the graduate route. The graduate visa route was introduced in July 2021, and it allows students to stay in the UK for 2 years or 3 years for PhD students after their graduation to work on an unsponsored basis in any role. And it's proposed that this route will be limited so that graduates can remain in the UK for a period of only 18 months after their studies rather than 2 years before needing to switch to an alternative visa route. Which will restrict flexibility for graduates as it'll give them a more limited opportunity to find sponsored work following the conclusion of their studies in the UK. And it does also mean that employers who've been employing individuals on a non-sponsored basis while they're on graduate visas will need to consider sooner whether they're prepared and able to offer sponsorship, and if so, to make arrangements for doing so. The Home Office also plans to introduce new English language requirements across immigration routes for both main visa applicants and their dependents. So the standard of English that workers, for example, on the skilled worker route, are required to meet will increase from B1 to B2 on the Common European Framework for Reference for Languages, or CEFR. And an English language requirement for all adult dependents will also be introduced at level A1 CEFR, with any visa extensions needing to demonstrate progression to level A2 and settlement applications needing to meet level B2. Currently, dependents of skilled workers don't have to pass an English language test, so this change will have a significant impact, particularly for dependents who might not have a strong grasp of the English language prior to relocating to the UK. And it's also likely this will increase costs for applicants, as in most cases they'll need to take and pass a Home Office approved English language test prior to making a visa application, and then may need to take further tests when they're applying to extend their visa and then settle in the UK. And on the topic of settlement, under the current system, an individual usually needs to have spent 5 years in the UK on an eligible visa route in order to be eligible for settlement, but the Home Office trailed in the white paper that they plan to increase this standard qualifying period to 10 years. The white paper does, however, say that they will continue to offer a 5-year pathway to settlement for certain individuals, for example, non-UK dependents of British citizens, or based on an individual's contribution to the UK economy and society. But the Home Office hasn't indicated how an individual will be eligible to qualify for that 5-year route, and have just said they will consult on these changes later in 2025. This change, if implemented, will have a significant impact on individuals seeking to make their home in the UK long term, because it remains to be seen how far and wide-ranging the 5-year pathway will be, and whether or not anyone eligible for that pathway will need to continue to make visa extension applications until they've accrued that period of residence in the UK. So, for example, every 2.5 years, as is currently required for most people on family visas. This would significantly increase these individuals' costs, as well as uncertainty of their long-term future in the UK until they've accrued those 10 years residence. So what next? Given the scope of these new changes and how soon they're being implemented, employers will need to take immediate steps to consider the impact they're going to have on their organisations. So we're advising employers at the moment to consider their current sponsored workforce, looking at whether the business is sponsoring anyone in codes or roles that are no longer eligible for the skilled worker route, and looking at what the increased minimum salaries are for any sponsored roles and how that will impact the business when a currently sponsored employee is then applying to extend their visa and they need to meet these new salary requirements. Employers will also need to be looking ahead at any individuals that they're considering sponsoring in future, to see whether the prospective roles are still eligible for sponsorship, what those increased minimum salaries are, and considering whether anyone can be prioritised for sponsorship before the 22nd of July so that their application could be considered under the current rules. If you've got any questions or need any advice on business immigration and matters or the changes that we've been through today, then please do reach out to me or another member of the immigration team, as we would be very happy to assist you. But for now, I'm going to hand back over to Sue for an update on the Employment Rights Bill.
Thanks, Ellen. So lots coming in the immigration place, and employment, it's no different. The Employment Rights Bill. So I had intended to quite quickly cover the government's new roadmap for implementation. But hot off the press, the government have also this week published a running list of amendments to the bill, which includes some very important government-backed amendments which were not previously known. So we're going to cover two of those amendments briefly as well. Let's dive straight into the timeline. So a lot of what's in the bill is going to be rolled out in stages from now right through to 2027. Broadly speaking, we're going to see consultations kicking off this summer and autumn. Then there's going to be some immediate changes when the bill gets royal assent. That's likely to be later this year. We'll then see the first wave of changes in April 26, a second in October 26, and you'll notice that we're staying with the usual employment law changes which always happen in April and October. And then the more controversial big stuff like the day one unfair dismissal rights is going to come in 2027. So starting with those consultations, we're expecting a flurry of consultations on various measures, and that may well change the time frame depending on what comes out of those. We kick off between summer and autumn this year with consultation over the introduction of day one unfair dismissal rights and the dismissal process and the new statutory probation period that goes along with that. Then in autumn, consultations are expected to take place on various trade union measures, fire and rehire, regulation of umbrella companies, increased rights for pregnant workers, and the ending of the exploitative use of 0 hours. Further consultation is going to follow, so between winter 25 and early 26, we're expecting issues such as tipping laws, collective redundancies, flexible working, before the first major wave of changes are introduced in April 26. So what are they going to be? Well, they're going to include doubling the collective redundancy award. So this is an award that's given, a protective award given where there's been a breach of collective redundancy consultation requirements, and that's expected to double from 90 days to 180 days pay. We're also going to see the scrapping of the existing service requirements for paternity leave and unpaid parental leave, the reform of statutory sick pay to make it available to low earners and it will be paid from day one of absence, and the establishment of the Fair Work Agency. So that's all expected to come in, according to the timeline, April 26. We also understand that equality action plans, which are going to be required to cover the steps that employers are planning to take to address their gender pay gap and how they're going to support employees through menopause. And we're expecting those to be introduced initially on a voluntary basis in April 26. October 26, so we see a bit of the heavier lifting coming in for employers here. Ban on fire and rehire is due to come in. We're going to cover that in a bit more detail later. And employers will have a new proactive duty to take all reasonable steps, as against just reasonable steps, to prevent sexual harassment. The standard tribunal time limit, so the time limit to bring a claim, will increase from 3 months to 6 months. And it's going to be very interesting to see how an already overstretched tribunal system copes with that change, alongside everything else that's going on here. And then we've got lots of new trade union rights, including the duty to inform workers that they can join a union. Then we hit 2027, And this is when the most significant employer burdens are due to come in. But that has been pushed back from where we'd initially expected. So what have we got there? Day one right to protection from unfair dismissal, measures for 0 hours and low hours contract workers, requirement for employers to produce equality action plans. That's what I mentioned earlier. It will now become compulsory. We've got increased rights for pregnant workers, giving additional protection against dismissal, the introduction of reasonableness requirement to refuse flexible working requests, and day one right to bereavement leave. So that's a very quick overview of what we've been told is the proposed timeline for implementation. What do we think of this? Well, it's clear that the government has taken on board the potential burden on employers of some of its key measures, such as that removal of the unfair dismissal qualifying period, the changes relating to 0 hours contract. And employers are no doubt going to welcome this further time to get to grips with those changes. There still seems to be some gaps in consultation and measures. So in particular, we've noted that around the introduction of the duty on employers to take all reasonable steps to prevent sexual harassment, what's surprising is that the duty to take all reasonable steps is due to come into force in October 26, but the power to make regulations, for the government to make regulations specifying what steps are to be regarded as reasonable, will only come into force in 27. So that leaves us with a gap there and some uncertainty when initially determining the appropriate steps to take to address that new duty. Employers who might be considering redundancies or restructuring should look closely at this timeline. We've got the doubling of the protective award being one of the earliest changes in April 26. And that's going to make it more difficult from that date for employees who may be minded to buy their way out of those requirements or indeed ignore them completely. It's going to be a lot more expensive. In addition, the restrictions around dismissal and re-engagement, fire and rehire, coming into force in October 26. So employers considering making contractual changes will want to look at that as soon as possible if they want to rely on the current legal position. So I mentioned at the start that we've also now got some updates on proposed amendments that we hadn't previously been aware of. I've listed some of them on the slide, but I'm just going to cover two which appear to be broadly government backed and therefore the most likely to be accepted. Let's start with the ban on some NDA, so non-disclosure agreements. The proposed amendment introduces a significant change to the enforceability of confidentiality clauses in employment agreements. What it does is it renders unenforceable any provision in a contract between an employer and a worker. So that includes settlement agreements, COT3s, employment contracts. So any provision that attempts to prevent or would have the effect of preventing the worker from making allegations or disclosures about harassment or discrimination, or the way the employer responds to such allegations or disclosures. So this change is framed as ending misuse of NDAs and fostering transparent and safe workplaces. But let's face it, this is going to be a major change for employers. You're going to need to audit your confidentiality wording in contracts, template settlement agreements, because any clause which would silence disclosures about equality breaches will be unenforceable. Now, we've been expecting this in terms of sexual harassment, but this covers almost all forms of discrimination under the Equality Act. Strangely, not allegations of failures to make reasonable adjustments, and as far as I'm aware, as far as I can see, not victimisation, but all other forms of discrimination, harassment on any protected characteristic. The obvious risk here, of course, is it could massively backfire, as employers are going to be less likely, I would have thought, to be willing to settle discrimination claims if there's no promise of confidentiality, particularly where they're confident at the prospect of defending a claim at tribunal. And that could have a lot of knock-on effects, both in the workplace and to the tribunal system. Now, this is a completely new introduction. I haven't seen it on the implementation roadmap, so I don't think we know yet when this will come into effect, but certainly one to be watching and to be looking at. Moving on to the second one I wanted to cover, one of the most talked about reforms in the bill is the proposed ban on fire and rehire. So, quick recap, the original version of the fire and rehire ban was incredibly broad. It would have made it automatically unfair to dismiss an employee for refusing any contractual change, no matter how outdated the clause, how reasonable the proposal, or how obstructive the employee's refusal. The only exception was if the business was on the brink of financial collapse. So that's really quite stringent on the employer. Under the proposed amendment, that's being softened significantly. So the headline of the amendment is the ban will only apply to restricted variations. So this is things like pay, pension, hours, holiday, and anything else that the Secretary of State might later want to include in regulations. But minor tweaks that don't touch those areas, like job title changes or reworded clauses, won't trigger the automatic unfair dismissal rules. There will be closer scrutiny than there currently is over the reason for the variation, the consultation that took place, and any sweetener offered to the employee in return for the change. But it does mean that employers do get the opportunity to justify and show that any dismissal for refusing to agree to the change was fair. As an anti-avoidance measure, the ban's also going to catch dismissals aimed at inserting a flexibility clause. So, for example, if there was a flexibility clause introduced that would let the employer reduce an employee's hours or pay in the future without their consent, so trying to get around those fire and rehire ban on the key provisions by the back door. Now, you'll still be able to include flexibility clauses in new contracts, and you'll still be able to rely on ones that already exist, but adding new flexibility clauses to existing contracts via dismissal and rehire are only going to be allowed in those very limited circumstances. So, key point there, key takeaway, if you haven't reviewed your flexibility clauses recently, now's the time to do it. So, all in all, if these amendments go through, the fire and rehire ban becomes much more targeted, a bit more workable for employers, and does mark a significant concession on the government's part. As ever, it's a case of keeping a watching brief. Get involved in those consultations if you want to. But with the new timeline that we've been given and the proposed amendments, employers can now start to look at addressing matters such as auditing those confidentiality provisions in contracts, settlement agreement templates, and just check your variation clauses in your employment contracts. So, wow, we have managed to do that just within the time allotted. So I'm really pleased about that. That does bring us to an end. Thank you for joining us for a very whistle-stop tour of some pretty extensive changes in employment and immigration. We're going to be holding our next webinar in October, and we'll be sending details of that out soon. But for now, thank you very much. Have a lovely sunny day.